Hi folks, today we're going to take a look at LIA, where he goes over the motion to dismiss his defamation case from the city of Melbourne, Florida. But before we start today's video, as always, a big thank you to all my current and new channel members and subscribers. Without all of your support, I couldn't keep the channel going, so I want to thank you all personally from the bottom of my heart, and a quick word from today's sponsor. Today's sponsor is Aura. We're online a lot, and let's be real, there's a lot of shady things online these days, and this is where today's sponsor, Aura, can come in and help you. Aura is an all-in-one digital security, protecting your personal data, monitoring your credit for you, has parental controls, VPN, antivirus, gives you 24-hour protection, and offers you a $1 million identity theft insurance policy. And why is Aura important to protect you? Well, we see a lot of things online that lead us to some websites that steal our data, then sell that stuff off to data brokers who can sell it and resell it, causing you to get spam calls, junk emails, and sign you up for things you didn't even want. But not only that, Aura puts an end to those pesky scam calls, the spam emails, and not only that, it can get your data removed from data brokering websites without you having to move a finger. Aura is offering you a free 14-day trial by using my link in the description box and signing up at aura.com/NCR or scanning the QR code. That's aura.com/NCR or scan the QR code for your free 14-day trial, and don't leave your data unsecured. Thank you again to Aura for sponsoring today's video, and don't forget to sign up for your free 14-day trial. Not only is it the best way to help keep your personal data safe, but it's the best way to help support me and the channel. With all that being said, let's enjoy today's video.
Hey, what's up guys? Long Island Audit here, back again with another video. Can everybody hear me okay? Put a 1 in the chat if you can hear me okay. Just want to make sure. Left my mic. Okay, good, perfect. All right, guys, thank you for joining me for this live stream. Please hit the like button and share this video anywhere you can on social media to expose this corrupt mayor to the world. We're talking about Melbourne, Florida Mayor Paul Alfrey. So for those of you who aren't familiar, I just showed you a clip of me serving him with a defamation lawsuit. The mayor and his esteemed legal team have filed a motion to dismiss. So right here, we're going to take a look at it together. I'm not an attorney, let's be clear. I am far from an attorney, far from a legal scholar. I never claimed to be. I have learned a lot from a lot of smart people, including attorneys, and this doesn't make any sense to me, but let's get right into it. And for those of you asking, I did not have court yesterday in Corrupticate. I know I was originally scheduled for November 3rd. It's been rescheduled for December 9th. All right, so you see here Sean Paul Reyes, plaintiff, v. Paul Sidney Alfrey, that is the mayor of Melbourne, Florida. So the reason why I'm suing him for defamation is because he made a Facebook post stating that I had sent him death threats.
Now, for those who are unaware of what led up to this lawsuit, LIA went to the city of Melbourne, Florida, by request of the mayor's ex-sister-in-law and niece due to allegations that they made against him and current investigation that is going on due to those accusations. Sean went to the city council meeting and made accusations that the mayor is having an affair, that he has stolen his late brother's credit card and misused it. All accusations that have not been proven yet. Not to mention, when Sean did go to the city council meeting, he was removed due to the fact that he expended his time and refused to leave the podium. Now, he encouraged his followers to redress his government and redress their government. The mayor did post on his Facebook page as the mayor of Melbourne, Florida, that he had received death threats due to a out-of-town YouTuber's followers. He did not directly accuse the out-of-town YouTuber. He said his followers had made the comments. Comments ranging from wishing cancer upon the mayor to saying it's coffin time, referring to his wife as a whore. These are things that are serious. But at no point in this whole post did the mayor specifically direct any blame to Sean or Long Island Audits the channel, but only claimed that an out-of-town YouTuber was the cause for this.
I have never sent anyone death threats, let alone a mayor of a city. So I wanted to hold him accountable for that. So I filed a lawsuit for defamation. And let's see here. We have the motion to dismiss the defendant Paul Alfrey through his undersigned counsel. Rule 1.140 Florida Rules of Civil Procedure hereby move to dismiss plaintiff Sean Paul Reyes' complaint in this action, and in support of said motion would state as follows. Legal standard: when deciding a motion to dismiss, the trial court is confined to the four corners of the complaint. So I will have an opportunity to respond as the plaintiff to this complaint, but I want you to really pay attention to this. When deciding a motion to dismiss, the trial court is confined to four corners, to the four corners of the complaint. That's going to come important later. The facts alleged must be accepted as true, and all reasonable inferences must be drawn in favor of the pleader, aka me. Moreover, the Florida Rule of Civil Procedure requires that plaintiffs make a short and plain statement of ultimate facts showing that the pleader is entitled to relief. Pleadings must contain ultimate facts supporting each element of the cause of action. Furthermore, Florida is a fact. I sound like I'm in an empty room or bathroom. That's because I left my microphone. We're going to have to work with it, guys.
Nobody cares you left your mic in the bathroom. Now, we're going to jump ahead to the actual outlines of the motion to dismiss.
Merely track the language of the statute and lack factual allegations. The complaint also fails to state a cause of action when contradictory allegations render the complaint legally insufficient. Furthermore, where there is a conflict between the allegations and the attached exhibit, the contents of the exhibit control over the allegations. A complaint fails to state a cause of action when the plaintiff fails to attach evidence for the pleading is based. So what they're basically saying is that I didn't attach the motion, the Facebook posts to the complaint. I did. I checked the county website, and just to make sure, I was like, wait, I thought I filed the Exhibit A and Exhibit B. Exhibit A was the Facebook post where the Mayor Paul Alfrey stated to his following that I had sent him death threats. And then he attached some not nice screenshots of people sending him messages, but they didn't send him death threats, to be clear. They were, I hope you die of cancer, things of that nature, things I don't support, but not death threats.
Shenanigans. Shenanigans. And we're calling shenanigans, folks, because Sean is wrong. Telling somebody that they wish they die of cancer and that they're going to be dead soon and making comments of that nature can be considered death threats in the state of Florida. Now, Sean may not be the one who actually called him those things or said those things, but not encouraging his followers to do so would be the best idea. When he's telling his followers to redress the government and he's making these claims of him being a tyrant and he's being corrupt and he's doing all of these things, he's fanning the flames of hatred. Now, he can do that, and he can also encourage them not to say anything violent, and that would still be perfectly fine. But since he's not calling for the de-escalation of violence or death threats from his followers, and he has a history of this happening, see Brian Fahey for that, you can understand where these threats are coming from and why the mayor says these would be threats to anyone else who's a rational human being who reads them.
To be clear. And then I also attached the retraction demand letter that I sent him. I sent him a demand letter saying, hey, issue a retraction about your lies against me, your defamatory statement saying that I sent you death threats. He failed to do so, so that's why I filed the lawsuit. So I served him with the lawsuit. A complaint based on a written instrument does not state a cause of action until the instrument or adequate portion thereof is attached to the incorporated in the complaint. And then it goes on, plaintiff lacks standing. This is very weird. Pay attention, guys. This is very weird. It is well-established case law that to have standing, a person must establish 1, an injury, 2, causation, and 3, redressability. 6, plaintiff is wrongfully claiming standing in this cause of action as an individual, despite being at the city council meeting in their capacity as Long Island Audit. to which plaintiff filmed a live stream and later posted under the name Long Island Audit. Let me just clear this up really quick. My channel is called Long Island Audit. Sometimes I go by the moniker of Long Island Audit. My company's name is Long Island Audit Inc. Excuse me, 1 second.
A few minutes later.
My company's name is Long Island Audit Inc. It is a corporation. It's incorporated in New York State. But my name, as you all know, is Sean Paul Reyes. I am an individual. I am not a corporation. So this is why this is weird. It is well recognized that a corporation, unlike a natural person, cannot represent itself and cannot appear in a court of law without an attorney, because I filed this defamation lawsuit pro se. Plaintiff is bringing this cause of action wrongfully as an individual as expressed above, and therefore as a corporation bringing forward a cause of action is required by Florida law to be represented by counsel in any of the proceedings before this court.
Now, this part of the motion to dismiss makes the most sense due to the fact that Sean was not referenced by name or by his company name, only as a out-of-town YouTuber. Now, that could be anybody who has a YouTube channel that lives outside of the city of Melbourne. It could be me. It could be you. It could be anybody who makes content. So it's so broad and so non-descriptive that it makes no sense. Yes, he refers to Sean as the out-of-town YouTuber who attended the city council meeting, but there were a lot of out-of-town YouTubers that day, because there were people from Turning Point USA who were there to try to get a road named after Charlie Kirk. But if he's doing this as himself pro se, as Sean Paul Reyes, and not Long Island Audits or Long Island Audit Inc., I think this part of the motion carries the most weight due to the fact that they're not calling him out by name or company name.
Under Florida Statute 607.1502, a foreign corporation transacting business in Florida may not prosecute or maintain an action or proceeding in this state until it has obtained a certificate of authority to transact business in this state. Further, because plaintiff is to be considered a corporation, plaintiff has failed to establish standing for bringing a cause of action as to all the knowledge of the defendant and as to the date of filing of this motion to dismiss.
Everybody got that? Good.
Plaintiff is not a registered Florida corporation and therefore lacks the ability to bring forth suit in Florida. So let me just break this down. Again, I'm not an attorney. This person, we'll get to the name of the attorney here, but that is an attorney, weirdly enough. You cannot just remember, we have to stay within the four corners of the complaint. For him to say that I am a foreign corporation and not an individual or natural person, I filed the lawsuit, as you can see, Sean Paul Reyes, let's move back up here, Sean Paul Reyes v. Paul Sidney Alfrey. I did not sue him as the mayor. I sued him as an individual, Paul Sidney Alfrey. I sued him as Sean Paul Reyes, which is my name. I am not a corporation. I own a corporation, but I am not a corporation. So that is a little weird, and I'm definitely not a foreign corporation in the sense of, Florida statute or anything like that. So you're saying I lack standing because I can't wait to answer this lawsuit.
Sean, you're taking things a bit too literal right now. They're not saying that you have to be a corporation to sue. What they're saying is you filed the motion or you filed this lawsuit incorrectly because you're filing it under a pro se litigant against Mayor Alfrey for comments he made on his mayoral page for the city of Melbourne on Facebook. You're saying that he made claims that you directly made death threats, even though you clearly showed us nothing that says that. I've seen him, and he did not directly call you out. He simply made the comment that a out-of-town YouTuber made a speech at the city council meeting, and that out-of-town YouTuber's followers had been making death threats. Nothing that he said in that Facebook post directly ties to you as an individual or to your company. That is why they're saying you don't have standing for this.
The bullying and all the ad hominem attacks we're going to get to later, so stay tuned. Hold on, we're getting there. Further is considered. How are you going to consider me a corporation? Like, I'm not a corporation. I own a corporation. I am the president and owner, founder, whatever you want to say. I am an officer of the corporation, but I am suing in my individual capacity as a person. Not you cannot. A business could not sue for defamation in Florida. I don't believe. Again, if there's any lawyers out there, feel free to chime in. I am not one. Let's see here. For purposes of the motion to dismiss, courts do not accept legal conclusions as true, even when they're presented as factual allegations. Here, plaintiff has only made legal and factual conclusions alleging damage without showing any proof otherwise. And in fact, plaintiff has gained followers, donations, notoriety, and posted several videos of which have all made money, all directly because of the plaintiff's interactions with the defendant. Let me be clear. My job is an independent journalist.
You're not even a real journalism. That's right.
My company is Long Island Audit Inc. Of course, I've gained subscribers. I've almost at 1 million. We're like 3,000 away, so make sure you subscribe. Of course, I've gained subscribers since the date I first interacted with Mayor Paul Alfrey. I gain subscribers every single day. It's great. We've been growing for the last 4 years, accumulated over 1 million, almost 1 million now subscribers. 500,000 on TikTok, 300,000 on Instagram, 450,000 on Facebook, etc., etc. And of course, as any business, as MSNBC, CNN, Fox News, ABC, they all make money reporting and engaging in journalism. So that always seems to boggle my mind. But anyway.
So you're admitting that you had no loss of revenue from the post made about that incident. You're actually gaining subscribers. You just admitted that as well. You've said that you've been making money from this. So there's no loss of revenue, no loss of reputation. You're not losing subscribers over this. You're gaining, your own words, you're gaining more subscribers. You're close to 1 million subscribers. Now, if this was so damning and affecting to you, you should be losing subscribers. You should be losing money. But that's not the case. That's why they're saying that there was no harm caused to you by that post. This is just a frivolous lawsuit. You're not understanding that. You fail to grasp this, that if you are saying that you have been defamed, that means your reputation has been tarnished, you're losing the ability to make money, and you're losing the respect of the community. A community that you don't reside in, first of all, is the city of Melbourne, but you're stating a fact that from these live streams, from these videos you've made, you've gained money and you've gained following. There's no harm to you.
Let's see here. Furthermore, plaintiff has named the wrong party as the defendant in this case. As based on the four corners of the complaint, it is clear that the post to social media was on defendant's official mayoral account and done so by the defendant in his capacity and scope as mayor. So you're saying that he made these defamatory statements as the mayor, not as Paul Sidney Alfrey. Well, and he says that he used his official account. That's just not true. The mayor, just because you call yourself Mayor Paul Alfrey, Melbourne Mayor Paul Alfrey, on your Facebook page, doesn't mean that it's an official account. That was actually first created as Paul Alfrey for mayor of Melbourne. It is a political account, a political organization. Facebook, I've requested from Facebook the page transparency, and it says that he is a political organization. It's not, I have requested documents from the city of Melbourne, and they tell me that they do not own the page, they do not run the page, they have nothing to do with the page. So as far as it being an official page, and that he said something as the mayor, that's just not true. Again,
Sean is failing to grasp this key fact here, that Paul Alfrey has two different Facebook pages. One as the mayor of the city of Melbourne, Florida, which the post originated from, which the threats went to, and not the personal page of Paul Alfrey. That's the thing Sean is forgetting. Now, just because the city does not run it or own it or maintain it does not mean it's still an unofficial page. It would be official due to the fact that he's posting things about the city and his duties as mayor on there. He's posting statements about downtown work or upcoming meetings or emergency event concerns about the hurricanes and stuff like that. He's using it for an official capacity to reach his constituents through social media. Just because he started it when he was running for mayor as a political organization still doesn't mean that it can't be an official page, because it would be official. It'd be no different if anybody who ran for mayor decided to make a Facebook page to get constituents to follow them on social media, to hear about their debates, to hear about their plans for the city and what they were doing as mayor, and their duties as mayor once they were elected.
This lawyer is horrible. Plaintiff fails in alleging a prima facie case of action against the defendant individually. In his official capacity as mayor, the defendant has absolute immunity for statements made while carrying out his mayoral duties. So that is true. The mayor does have absolute immunity for statements made while carrying out his official duties. But his official duties are not lying about me, saying that I made death threats against him. I mean, I know there's not a lot of lawyers watching it. And again, I'm not a lawyer. I'm just trying to understand this here. You can't just say whatever you want, Mayor Paul Alfrey and his attorneys. You can't just say whatever you want and be like, oh, I'm the mayor. I said it on a page, on a Facebook page where I titled it Mayor Paul Alfrey. I can title my Facebook page Mayor Sean Paul Reyes. Doesn't mean I'm the mayor, and it doesn't mean that I am engaging in official conduct. You know, he's promoting businesses. He's doing a lot of things that don't. And remember, this mayor is corrupt as they come. How come he didn't file a countersuit for defamation? I've called him corrupt a million times because he is corrupt. I will leave a link in the description below where I showed his actual corruption.
Now, would that be a link to the video that I covered already, where you flat out said you don't have all the proof, but you can see it that it's, that it's corruption? You really didn't put anything out there that said, hey, this mayor is corrupt. You just basically said, well, these crumbs lead to this trail, but these crumbs lead over to this trail, but I know it's corruption. That's not corruption. Sean, your statement that you made that, I could put mayor on my Facebook page. Well, you could. It still wouldn't mean anything, but you're taking out the context of what that page is posting. If that page is posting things about the city of Melbourne, businesses that are coming in, press conferences, updates to emergency advisories, things about the city and things that the mayor is doing as mayor, like attending ceremonies or giving out awards from the city to people, that would be an official page. That would be the mayor posting about his official duties. Yes, the mayor has to take criticism as a public figure because he is open to a lot more scrutiny as a public figure. Now, if you were challenging him directly with comments as Paul Alfrey and not the mayor, then that would be a different story, which he could file a lawsuit against you.
Him receiving money, federal grant money that he signed over to a company, Habitat for Humanity, and then received almost $10,000 of that federal money as a subcontractor with his roofing company. I have the checks. Again, I'll leave the link in the description right below the like button, so you can check it out yourself. He is as corrupt as they come. It's only a matter of time before he's indicted, removed from office, and put in jail where he belongs. But yeah, no. Yeah, you would have official, you're not talking about the police or a policy or anything like that. You are defaming me. That's not how immunity works. Let's see here. The Florida 3rd District Court of Appeals held that the public interest requires that statements made by officials of all branches of government in connection with their official duties be absolutely privileged. Falsely stating and defaming me, stating that I am committing a felony. It is a felony to send someone death threats, especially a mayor. It is a felony. So, I don't get it. Anyway, it's not your official duties.
Wrong, 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 wrong. Wrong, 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 wrong. You're wrong, you're wrong, you're wrong.
The I can't wait to respond to this. The court explained that democracy needs free and open explanations of governmental actions, and this absolute privilege serves that necessity. Yeah, no, again, stating them sending you death threats is not absolutely privileged, and it's not an official action of the mayor. Plaintiff has attempted to bypass this legal protection, but as stated above, the contradiction in the allegations in the exhibits leads to the exhibits controlling, and it is made very clear the exhibits that the post was made on Paul Alfrey's official mayor page. Again, I have the email from the city clerk telling me it's not an official page of the city of Melbourne.
That just means it's not owned by the city. It's still the official page for Paul Mayor Alfrey, because he is posting things on there as his duty as mayor. It's still an official mayoral page, Sean. You're grasping at straws that are literally bending the minute you touch them.
That's it. Furthermore, plaintiff makes several claims of damage or injury, yet plaintiff has made several YouTube videos on this matter, by and through these videos and self-created viralness of this matter. Plaintiff has gained followers, notoriety, and attacking the mayor in any way possible and attempting to bully the mayor into resigning. Bully the mayor into resigning. I'm not trying to bully him into resigning. It's kind of like friendly advice. You should resign because you're corrupt as hell. And I've conducted a thorough investigation, better than the FDLE, the FBI, anybody else that's looking into you at this point. I found the goods on you that you are corrupt as hell. Pay to play.
So you're telling me that you have more resources than the state of Florida to do this investigation. So you're telling me you have the ability to subpoena banks for bank statements and records? Because you can't do that. You're not a lawyer. You're not a judge. You don't have any ability to issue out any kind of a warrant or subpoena for anything, except for a pro se litigant for a civil case or in your defamatory case. You know, you don't have the investigators like they have. You don't have the tools, the resources, but yet you go off of, oh, well, I got an email, I got a phone call, the family gave me this. You're being biased. You're not actually conducting an actual investigation. You're going off of what you're given with no verification of any proof, because you can't verify half the things you're given. You can't verify through the bank if those charges are being paid off. You can't verify who has access to the card in question, because you're not privy to that information. The banks would not give it to you. The text exchanges are questionable at very best, because who would be in that conversation listed as terrible human being or as liar? You know, those things are questionable as well.
It's crazy. Plaintiff's actions against public officials are exactly what his current... Plaintiff has not lost viewers or followers, as this is exactly what plaintiff does in their interactions with public officials. Plaintiff's actions against public officials are exactly what his current followers expect from him. As well, yeah, I think my followers expect me to call out corrupt government officials. I think that's what this whole channel is about, and reporting on that, as well as attract new followers. Yeah, we're almost at 1 million. Subscribe. For a defamation, the plaintiff must establish and prove the following elements: publication, Facebook post, falsity, I never sent you death threats, and the actor must act with knowledge of reckless disregard as to the falsity of the matter concerning a public official. He did. He knew I didn't send him death threats. He said it anyway. And when I told him to issue a retraction, he refused. That's malice and reckless disregard. Actual damages. You don't need actual damages in a per se defamation lawsuit. Again, any lawyers out there, it's defamation per se. He accused me of a crime. Accusing someone of committing a felony, the damages are assumed. Anyway, statement must be defamatory. It is. Plaintiff is only able to prove element 1, as it is undisputed that the statements were published. In count 1, plaintiff alleges a cause of action for defamation per se in an attempt to satisfy the elements, there you go, for a cause of action for defamation, which is commingling of the elements. And Florida courts have continuously held to not be permissible in the complaint. Plaintiff alleges that this cause of action against the defendant individually, but as stated above, the post was made from the defendant's official mayoral Facebook page. It's not. They're lying. These are lies.
No, they are not lying. That Facebook page is set up as his official Facebook page as mayor of the city of Melbourne, Florida. He posts things only related to the city of Melbourne as his duties as mayor. So it makes it an official page. Even though it is not owned or operated by the city, it is still him posting things officially as the mayor of the city of Melbourne. And you have not been defamed. You haven't provided any real evidence showing that you've been defamed by that post. You've actually showed us the opposite. You showed us that the post has gathered you more followers, has gathered you more money. You haven't provided the proper evidence. You don't have legal standing because you weren't named. The description as a out-of-town YouTuber is too vague. There could be anybody who's an out-of-town YouTuber who's gone to that meeting, because there were plenty of them, and, you know, it's just a vague statement. It's a broad statement. It's a descriptive term. Now, if he would have said your name or your company or your channel name, then that would be different. Your arguments here on how this is frivolous is wrong. How it doesn't make sense and it doesn't make the standing to be dismissed is false.
Mayor Paul Alfrey is lying, or his attorney, one of them. It's not his official mayoral page, and in the capacity as mayor. And those statements weren't made as a capacity of mayor. They were made from somebody trying to protect their image, you know, after I called them corrupt. Plaintiff alleges they were defamed, yet no other person or entity, including the plaintiff, is named or suggested in the defendant's social media post. That's not true. He said the out-of-town YouTuber. He didn't say Sean Paul Reyes or even Long Island Audit, but he said the out-of-town YouTuber sent me death threats. So, again, you're allowed to suggest. Innuendo is properly cited in the statute. Whew. Paul, I hope you're not paying these lawyers a lot. Anyway, plaintiff.
Okay, so he's definitely not getting this. We're going to have to break it down even simpler for him. Now, if I was to say that a out-of-town YouTuber got into an altercation with me, that is a very broad statement. It's a descriptive statement of another person. Now, if I was to say a specific YouTuber, like if I was to say Long Island Audits got into an altercation with me, NCR, that would be a defamatory statement because I am making it specifically about him. In the mayor's post, he did not say Long Island Audit. He did not say Long Island Inc. He did not say Sean Paul Reyes. He simply made the statement of a out-of-town YouTuber. That is a descriptive title. That is a descriptive observation of who you are, but it doesn't specifically target you. It's non-specific. Again, if he would have said an out-of-town YouTuber from Long Island, then that would be more directly towards you. If he would have said Sean Paul Reyes, the owner of Long Island Audit YouTube channel, then yes, that's highly directed towards you. But he didn't. And that's the problem you're not grasping.
Fails to provide any well-pleaded allegations to indicate malice. I just did. He didn't issue a retraction. He knew that these were false statements. That's malice. Plaintiff alleges damages without any proof of indication of injury or damage. It's reputational damage. It's per se, defamation per se. You accused me of committing a felony. Plaintiff makes multiple factual or legal conclusions without any support of case law, facts, or exhibits. I did include exhibits. Again, you're wrong. You're just lying. Further, plaintiff alleges defendant made a false statement of fact about the plaintiff, yet defendant did not name the plaintiff in the statement or made any statement that was false. Yes, you did. You said that I sent you death threats, the YouTuber from New York, out-of-town YouTuber, however you referred to me, and you said I sent you death threats. That is a false statement.
You know, it would be nice if Sean could provide us with this information that he has. You know, the evidence he has. He could show us, because it wouldn't be harmful for his case, because it would have been on a public Facebook page for the mayor of Melbourne, Florida, that you said you have screenshots of, that you provided to the court. Why not provide it to your audience? Why not show that? Because it would dismiss your case, because it would harm your case with your fans, because they would know that Oh, wait a minute. The mayor didn't say that. Sean's lying. Why would he say that? It's because he wants to fan the flames. He wants to rally people up because that's what Sean does.
Oh, man. The court noted that the outside of a suit, litigants must state their pleadings with sufficient particularity for a defense to be prepared. Very particular, my complaint was. The inability for a defendant to properly understand what they have been accused of denies a defendant adequate notice to prepare for an effective defense. Ugh, I mean, come on. I told you it was very, it was very specific. The inability for the defendants to properly understand what they have been accused of. Okay, I read that already. Plaintiff's argument that the defendant's failure and refusal to retract, correct, clarify, or apologize proves no basis of actual malice and is legally meritless and should not be substituted for factual assertions that the defendant knowingly or recklessly published a false statement. I mean, I think it does. I guess that's up for a judge to decide. Therefore, count one of the complaint fails on its face to properly state a cause of action for which relief can be granted. It is so ambiguous and vague. What's ambiguous and vague about he lied about me saying that I sent him death threats when I didn't? What is ambiguous or vague about that? I don't get it. To inhibit the defendant to raise or plead a defense and commingles different causes of actions to satisfy elements for the cause of action of defamation.
Now, we're going to end it here for now. There is still more to go over, so we will be doing that in another video coming out this week. But from what we've seen so far, Sean has not met any elements to show that he's been defamed in any way, that the mayor's statements were defamatory in any nature, and that Sean has no merit for his case. So if you guys like this video, please like, share, and subscribe. Leave a thumbs up and a comment because it helps me with the algorithm. Don't forget to check out my second channel, the podcast, and don't forget to sign up for your free 14-day trial of Aura. With all that being said, be well, be safe, and I will see you guys next time. And a very special thank you to all members of the news team. Without all of your support, I couldn't keep the channel going. So I want to thank you all personally from the bottom of my heart. You guys mean the world to me, and I could never thank you enough for all the support and encouragement you guys give. You guys rock.